Let's take a look at federalism in public administration. Federalism, the division of power and sovereignty between the federal government and the states, is another constitutional arrangement of great importance to U.S. public administration. The constitutional law of federalism is defined by the commerce and spending clauses in Article 1 as well as by the Tenth and Eleventh Amendments. The Tenth Amendment most succinctly underscores this basic theory of federalism. The federal government is one of limited powers, whereas states have largely open-ended sovereignty over a very broad range of public policy areas. The key issue in assessing federalism is determining which powers are defined to the states and which are vested in the federal government. Because the state's powers are open-ended, it's easier to say what they cannot do as opposed to what they can do under the Constitution. Prohibitions on state activity in Article 1, Section 10 include entering into treaties, alliances, and confederations, coining money, passing ex post facto laws, bills attainder, and laws impairing the obligation of contracts, and granting titles of nobility. In addition to these limitations, the states are directly constrained by several constitutional amendments. In terms of contemporary administration, the 14th Amendment is most important. It reads in part, "Nor shall any state deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the laws." The federal courts have interpreted the word liberty to incorporate much of the Bill of Rights, for example, the first 10 amendments, and to apply their restrictions, which originally pertained to the federal government, to the states. Federalism is more complicated when the states are denied powers because they are constitutionally vested in the federal government. The Commerce Clause, in particular, has been central to defining the scope of federal and state powers. It authorizes Congress to regulate commerce with foreign nations and among the several states and with Indian tribes. However, it does not define commerce or among. The Supreme Court's interpretation of these words changes over time and thereby alters the balance of federal and state power. Preemption doctrine is also complex. The fact that Congress regulates something, such as the environment, does not automatically mean that the states lose all power to address the same policy area. Federal preemption can also be based on the Commerce Clause alone. A judicial construct called the negative or dormant Commerce Clause prohibits states and local governments from passing regulations that discriminate against interstate commerce or impose burdens on interstate commerce that are clearly excessive in relation to the putative local benefits. The unusual motive for discrimination is to retain as much economic activity as possible within a state. For instance, a state might try, probably unsuccessfully, to require that all timber or shrimp harvested within its borders be processed there as well. The 10th Amendment reiterates the concept of dual sovereignty, whereby the federal government is sovereign in some areas and the states in others. The residuary state powers it protects necessarily varies with judicial interpretation of the Commerce Clause. The broader state sovereignty under the 10th Amendment and narrower Commerce Clause and vice versa. Today, the amendment's main ramification for public administration is to prohibit the federal government from compelling the states to enact or administer a federal regulatory program. This means Congress cannot conscript or press state officials to implement federal laws, other than those statutes regarding the states themselves. The 11th Amendment, 1795, protects the states' sovereign immunity by preserving suits against them in federal court. It provides that the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state.